Hello, my name is Dan Callahan. I'm the former managing partner of Callahan Blaine in Santa Ana, California. Callahan Blaine is known for achieving tremendous victories on behalf of its clients. Personally, I've obtained the highest recoveries in Orange County, California history in 4 separate areas of the law. $38 million in an employment case, $58 million for insurance bad faith, $934 million for business litigation, which is also the highest verdict for any case in Orange County history, and a personal injury settlement of $50 million, which was reported to be the highest personal injury settlement at the time in United States history. Making these victories even more significant is the fact that half of my time I represented defendants and secured unanimous jury verdicts for the defense. So now I'm the CEO of Callahan Consulting Group, which provides services to attorneys and to clients. Basically, Callahan Consulting Group performs 2 distinct and valuable services for attorneys and for clients. Briefly, for clients, Callahan Consulting will find the best attorney in a particular specialty for a client in the client's geographical area. For attorneys, I provide consulting services for junior and senior attorneys on trial practice and trial strategy. So let me explain in more detail these services. First of all, the services that I provide for clients is to interview the individual client and find out what the client's needs are. Whether the client needs an intellectual property lawyer, or an estate attorney, a business litigator, a personal injury attorney, or other attorney in a different specialty. I then will check various sources such as super lawyers, Martindale Humble, Avo, and others in the client's geographical area to find the attorney who has had the most success in the individual specialty. Once I have narrowed down the top candidates for the client, I will check each of their websites to make sure they have significant recent jury verdicts and/or settlements. Once I've further confirmed that these attorneys have the ability to handle the client's case, I will arrange for a telephone conference with them and personally interview the candidates to make sure that they presently have the ability and capacity to handle a new matter, and that the attorney I'm interviewing will in fact be the lead attorney on the file if we do direct the client to this attorney. I want to make sure that the client's matter is not passed off to a junior associate or to someone who has not achieved the same verdicts and/or settlements that are being touted by the law firm on their websites. Once I'm satisfied that I've found the 2 or 3 leading attorneys in the geographical community specializing in the area of law that the client needs, I will arrange for a conference call between myself, the client, and the attorney. During that call, I will help the client interview each of the candidates. After these interviews, I will speak with the client, discuss the prospects, and assist the client in selecting the best attorney. This service costs the client nothing. Rather, the attorney pays a referral fee to Callahan Consulting Group at no expense to the client. After the attorney has been selected and a retainer agreement has been prepared and executed, I am available to the client to confer on any issue that may arise concerning the representation. I will not abandon the client once the client has made a selection of an attorney, nor will I interfere in the representation provided by the attorney. I will remain available if any issues arise. Switching now to the other prong of service provided by Callahan Consulting Group, I also mentor both junior and senior attorneys on trial practice, skill, and strategy, as I've been doing with my own partners and associates for many years. Over my 40 years of being a trial attorney, I've learned very creative ways to reach outstanding results. By example, the $934 million unanimous jury verdict that I mentioned previously did not start out to be a huge case. It was a $2 million breach of contract case that I amended 7 weeks into the 3-month trial to add 2 additional causes of action based upon evidence I induced in trial testimony. The jury awarded me the $2 million on the first cause of action for breach of contract, $300,000 plus $1 million in punitive damages on the second cause of action for fraud, the evidence for which I uncovered during pretrial discovery, and on the 2 initial causes of action that I added during the trial. The jury gave me $180 million in punitive damages on the first and $750 million in punitive damages on the second. Those results were obtained through hard work and creativity. Those are the traits and skills that I teach attorneys throughout the nation, just as I had done for many years as the managing partner of Callahan Blaine. There are several examples during my career of creative lawyering. Here are a couple of additional examples. First, I represented a manufacturer of a product used at a construction site. My client was from out of state and not familiar with the mechanics lien rules in California. When he was not being paid by a subcontractor, he wanted to get a mechanics lien. I asked if he had given the owner of the property the required 20-day notice that he was providing materials to the job site. That is a condition prerequisite to getting a mechanics lien in California. Unfortunately, the client was not aware of that and had not given the owner such notice. However, in speaking with the client, I learned that the subcontractor had bought the materials from the client on credit while the subcontractor was technically insolvent. I remembered under the UCC that if someone sells product to someone on credit while that individual is insolvent, that the seller can reclaim constructive possession of the goods by demanding it. Therefore, on behalf of the client, I notified the property owner and the subcontractor that my client was taking constructive possession of the goods without the goods ever leaving a locked warehouse on the owner's property. I then gave the 20-day notice and released possession of the goods back to the owner. The attorney for the owner, the largest company in the county, disregarded my grafting the UCC statute onto the mechanics lien statute and paid the subcontractor over my objections. Therefore, we sued the owner of the property, and the court agreed with me, and the owner of the property was required to pay my client, even though he had already paid for the same goods to the same subcontractor, who, by the way, by that time had filed bankruptcy. The second example of creative lawyering is I represented a lender who had a security interest in all of the debtor company's equipment. When the debtor was not paying the lender was afraid that the debtor was going to abscond with all of the equipment if we filed a lawsuit and had to go through the normal process. Therefore, relying on a different provision in the UCC for self-help repossession, which a creditor may exercise as long as it does not breach the peace, I went to the debtor's job site, a large factory and warehouse, and demanded possession of the collateral. Now, ordinarily, you would think that the debtor would tell me no. However, in this situation, I served the debtor with a form that I drafted reciting the statute that I was relying on and came to the debtor's property with a policeman. The policeman came to make sure I did not breach a peace. But to the debtor, it appeared that the police were there to enforce the collection. I also brought a videographer to film everyone at the scene. I told the people at the door that if they pointed out the equipment belonging to my client, the lender, that I would not personally sue them. The employees that I spoke with pointed out the various pieces of collateral, and I used a forklift that I had brought to the scene on the back of a flatbed truck and loaded all of the equipment onto the truck and drove away. I was contacted that afternoon by the attorney for the debtor, and he said, "Is it true all they had to say was no?" And I said, "Yes." The attorney laughed and said, "Congratulations on your sting." Because of this effort, my client, the lender, was able to retrieve all of the collateral and avoid taking a substantial loss. And I got the result the client wanted without needlessly incurring large amounts of attorney's fees and suffering the delay and uncertainty that often comes with a prolonged litigation. As you can tell, the examples I just gave you demonstrate substantial creativity. One of the hallmarks of my many successes is to be creative and to think outside the box. I do not labor through the protracted litigation if I can find an easier and more effective way to obtain the desired results. So I hope that you now understand what Callahan Consulting Group does, and that you will find that this service and approach would be valuable to you. Thank you.